This is the Rule of Law Radio, Thursday night 2-hour show. This is Eddie Craig, Randy Kelton, Deborah Stevens. It is September 20th, 2012. And tonight's show, Randy has some material he wants to present over some research he's been doing. Randy?
Howdy. Yeah, I have been doing a lot of research. I've went back and reread the Deed of Trust a couple of times. Right now, most of my research is in foreclosure and not in due process. As actually, I have a friend up here who, well, he's out of Waco, but I got a letter from the Wise County Jail. He's in the Wise County Jail. And I spent about an hour and a half with the county attorney today. He was doing everything he could to keep me from picking up the traffic issue in Wise County, trying to convince me that this was probably the only county where I had a friendly voice. So I'm like, I want to go screw with people in other counties. And his advice was well-founded. But anyway, I've been doing a lot of research on the Deed of Trust, and just from going through the document itself, it surprises me at how many things the lenders are violating as a matter of course. And nobody's bringing them up. The lawyers aren't bringing them up. I'm not seeing them on the webs. People on the web, they bought this MERS Kool-Aid. And everybody's arguing about MERS this and MERS that. And MERS doesn't have this capacity or that capacity. And they're talking about the bifurcation of the note and all of this securitizing of the note. I am surprised at how much these people apparently don't know. And it doesn't seem like anybody's actually read the Deed of Trust. We were having trouble with the banks throwing out our claims on Hopotelia Respa, the federal consumer protection laws. The feds created these consumer protection laws. And since these were not constitutional, but were statutory, since the legislature created them, the legislature had the right to limit their application and most specifically set a statute of limitations on when you could make a claim under that. And they passed the statute and made it look as though it was a very strong consumer protection law. And then they set a statute of limitations on exercising it to 1 year, 2 year, and 3 year. And when you're talking a 30-year mortgage, and these folks are doing things that the consumer has no knowledge that what they're doing is wrong, it takes a long time to figure out what all went on. So in effect, the consumer protection laws are of very little value, except when you read the Deed of Trust. And I don't know how many times I've read it, and it seems like every time I read it, I catch something else. In Covenant 15 of both deeds of trusts and mortgages require the lender to provide all notices prescribed by law in writing by certified mail. Now, if you have a mortgage, how many of the notices that you received did you receive by certified mail? I've never talked to anybody who received any by certified mail. So instead of going after Hopotelia Respa, and primarily the limitations on the enforcement of Hopotelia Respa were the notices. That's what the limitations were put on. Well, the deed of trust doesn't put that limitation on. If they didn't send it to you by certified mail, then there is no limitation on it. The limitation is no greater than the limits of the contract itself. And the primary reason I'm looking at the deed of trust, the deed of trust, if we make our argument right, should be the easiest place for us to confound the lender. There are two things it does. The deed of trust grants two privileges to the lender. The first privilege it grants to the lender is in the form of a mortgage. And in this respect, all mortgages will be essentially the same as the deed of trust. And what the mortgage portion of the deed of trust does is give the lender a claim against the property. Now, that's important because the lender needs to be able to ensure that if he's giving such a large loan against the property, he needs the property as collateral against default on the loan. In order to get the property as collateral, he has to have the mortgage. And this allows him to ensure that you don't sell the property to someone else, that you don't destroy the property, that you don't let it fall into disarray, that you don't take everything out of it and sell it, and then tell him to go ahead and foreclose on it, and then you've stripped value out of the property. There's a lot of things it's in there for, but that's what the mortgage does. It gives him a claim against the property so that he can thereby restrict what you do with the property. Now, the restrictions only go to maintaining it, insurance on it. They only go to protecting the collateral in case he has to default. The second privilege the deed of trust grants is a confessed judgment. With a mortgage, he would have to go to the court and get a judgment. Without a mortgage, he would have to sue the individual, secure a claim against the individual, and then go to the court and ask for a judgment against the property. With a mortgage, he can do an in rem suit and sue against the property directly. So he automatically gets the claim against the property. With a deed of trust, he has a confessed judgment. So he doesn't even have to go to the court to get the judgment. You have already agreed to all of it. So that's a privilege. They're both privileges that you granted to the lender in return for consideration on note. But you granted those with conditions. And we'll get into some interesting conditions in a bit when we get to the MERS issue. But here we're just talking about the deed of trust, even if you don't have MERS in it. Paragraph 15 goes to all of the notices. If they haven't sent you all of the notices by certified mail, that's a breach of the covenant of the contract. Now, if you've ever looked at a notice of default or a notice of intent to sell, they will both claim breaches of covenants of the deed of trust. So if you breach covenant of the deed of trust, they can exercise the confessed judgment in the deed of trust. And the position we're taking, if the lender breaches covenants of the deed of trust, the lender repudiates the contract. And in so doing, his repudiation of the contract effects voluntary rescission. So he voids the contract. Now, the only thing the contract and the deed of trust does is grant him a privilege. It doesn't in any way affect his right to collection of the monies claimed in the note. It just makes it easier for him to do it. It's convenient. So what we're saying is, He doesn't have the right to this convenience because he breached covenants of the agreement that granted him the convenience. Now, that one doesn't sound like too much, and well, perhaps it's not, but it's enough. But there's more. Paragraph 19, generally, covenant 19, is generally where this one's at. Sometimes it moves around. If the note is paid off, then the lender is required to return the security instrument to the borrower. So when a lender enforces a deed of trust and forecloses on a property, until he returns the original deed of trust and note, the note portion of this is in the Uniform Commercial Code, until he returns those documents to you, the sale is not complete because the trustee was authorized to do the sale, or the lender was authorized to make a claim against the property based on these conditions. Even in a mortgage, where they're authorized to sell under the mortgage, it has the same condition. Once they're paid off, they have to return the original note. And those folks who've been around a little longer than I do have probably remember mortgage burning parties. They'd pay off the mortgage would be returned to them, and then they would go burn it. And that's to make sure nobody else gets it and tries to express it. So until that is returned, the sale is not complete. Paragraph 20, or Covenant 20, that's the one that authorizes the lender to sell a portion of the note or the entire note. Now, that's where when you read Uniform Commercial Code and the deed of trust, they seem to be somewhat convoluted and contradictory. We'll get to that when we come back. This is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
Thought that I was doing well, but the truth to you I'll tell. MSGs and GMO really ain't the way to go. There's a better way I've seen. It's called tangy tangerine, and we're all drinking tangy tangerine, tangy tangerine, tangy tangerine. We're all drinking tangy tangerine, tangy tangerine, tangy tangerine.
Order Beyond Tangy Tangerine and other great longevity products at LogosRadioNetwork.com by clicking on the Tangy Tangerine banner. Sign up as a preferred customer for wholesale prices or become a distributor and support LogosRadioNetwork.com. So what do you say, Elvis?
Thank you very much.
Are you being harassed by debt collectors with phone calls, letters, or even lawsuits? Stop debt collectors now with the Michael Mirris proven method. Michael Mirris has won 6 cases in federal court against debt collectors, and now you can win too. You'll get step-by-step instructions in plain English on how to win in court using federal civil rights statutes, what to do when contacted by phone, mail, or court summons, how to answer letters and phone calls, how to get debt collectors out of your credit report, how to turn the financial tables on them and make them pay you to go away. The Michael Mirris proven method is the solution for how to stop debt collectors. Personal consultation is available as well. For more information, please visit ruleoflawradio.com and click on the blue Michael Mirris banner or email michaelmirris@yahoo.com. That's ruleoflawradio.com or email michaelmirras@yahoo.com to learn how to stop debt collectors now.
Look what we got. We are the
want we think make it easy. Them a talk we too politically and them getting mad and angry. But them not standing up and fight for the freedom and be free. And they like them love slavery and get handout from the government. We ask the question, wonder what they're hiding. Don't have the answer. We ask the question, look what we get, and they don't have the answer. Slope and slippery slide. Tyranny, them a tear you, them a tear me, Lord, them a take the country.
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio, and we're talking about the deed of trust. If anybody out there's got a deed of trust, I'm sure nobody's listening to this program that hasn't heard the talk about all the problems with the mortgage industry. Well, frankly, it's worse than you think. I have been examining county records, and what I'm finding is an absolute horrible mess. But in order to get the judges to agree with us, we have to be able to frame this in a way that'll make sense to the courts. People have been coming in making these arguments about how MERS claims to be a beneficiary. It's not really beneficiary, but they also claim to hold the legal title, but they don't really hold legal title. And the judge sits there and his eyes glaze over. And they talk about MERS business model. I really think that the banks waved MERS at us like a red flag in front of a bull. And they said, oh, look at MERS. Look how vulnerable they are. Come and beat up on MERS. And that's because that sent us all to a central location. Now the banks have one entity handling all their notes for them, and now they sent us chasing MERS. Now they have one entity handling all their suits for them. Nice and convenient. But as far as I'm concerned, MERS is not an important part of the mortgage process, other than its relationship to the deed of trust, and I'll get to that in a minute. We were talking about paragraph 20 about selling the note and the deed of trust. Well, in looking at the Uniform Commercial Code, in one part of the code, it calls the note a negotiable instrument. However, when you read the definition of negotiable instrument in the Uniform Commercial Code, it states that a promise to pay a specific individual is not a negotiable instrument. Only an instrument endorsed in blank or written essentially in blank is like a bearer bond, or pay to the bearer, or a check written to cash is a negotiable instrument. But a check written to a specific individual is not a negotiable instrument. But they're calling it a negotiable instrument. That's something I'm still working on. I haven't briefed out. There may be exceptions having to do with the real estate mortgages. I haven't found that yet. But there are a lot of questions, a lot of complex issues here. And while the complex issues make it difficult for us to figure it out, I think in the end it's a tremendous advantage for us. We think of lawyers as being so knowledgeable and learned counsel. Well, maybe they are. But if the lawyer's going to pay $40, $50 a year in malpractice insurance, and then he's going to pay secretaries and paralegals, he does not have the time to do the kind of sophisticated research that I've been doing lately. And their problem is the internet. One person can do the internet and then make it available to hundreds. And the courts are complaining now because some 20% of all cases now are pro se. And it's driving them nuts because you have this guy that's losing his house. He don't have a job, so he's spending all day in the legal library researching stuff he can throw at the courts. And these lawyers, they never do that kind of thing. Lawyers only file what they've always filed. When I go to a lawyer with a sophisticated argument that they haven't addressed before, these lawyers do not want to touch it. They don't want to come in there and make an argument and have the other side come back and say, look, this has already been well adjudicated. This argument is frivolous, and here's the reason why. And they're afraid there's going to be something out there they've missed. And if you go down to the legal library and look around at all the books in there, you can understand why they have that fear. Their fear is much greater than ours because they can have their bar card pulled. They are supposed to be learned counsel. Their problem is they don't have enough time to be as learned as they want to be, or they need to be. So most of the time, they're shuck and jiving counsel. They're faking it. And they only do the same things over and over. Part of the reason they hate pro ses. The pro se comes in, brings up an argument they haven't seen before, and they don't seem to be able to address it. So, from the perspective of the pro se from hell, and I got my training from Eddie on finding issues they haven't addressed, I'm finding a bunch of them. Now, paragraph 20 is pretty straightforward in that they are authorized to sell the note and sell and transfer. Reading up on that in UCC, Uniform Commercial Code, says that the owner of a note can transfer the note. But, let me make sure I get this right. But if someone is not the original owner of the note, they can negotiate the note. And probably next week I'll have a more sophisticated analysis of what the difference in those two are. I'll address those later. I probably shouldn't have brought that up yet because I haven't researched it out enough. But paragraph 20, they're authorized to sell a portion of the note or the entire note, brackets, together with this security instrument. And of late, when we get a assignment, the assignments used to just say they transferred the deed of trust. Now they're saying that they're transferring the note and the deed of trust. Well, I have case law that says that's horse manure. That just stating that you're transferring the note and the deed of trust is insufficient. There has to be physical evidence of the actual transfer. So that's another breach of the deed of trust. If we find that the servicer doesn't have the same name as the original lender, or the servicer claims that he's working, it doesn't have the same name as his principal. The servicer claims to be holding the deed of trust. So if he's a servicer for a principal, then the principal has to be holding the note. The servicer would have to claim that the principal is holding the note and the deed of trust and prove that. In fact, they're not. And why these guys are doing it this way, I have no idea. If they transfer the note into a pass-through trust, then the trustee becomes the holder. You know, everybody's saying that, you know, they negotiate these notes into a pass-through trust, and then they sell pieces of them all over the place. Well, none of those people have power to enforce the note, and that's right, they don't. That's why it's a pass-through trust. The trustee has power to collect on the note, because none of those guys hold the whole note. Only the trustee does. This is Randy Kelton, Deborah Stevens, Eddie Craig, Real Radio. Larry, I see you there. I've got one more segment. I got a couple of really interesting things, and then we will go to calls. Okay, our call-in number, 512-646-1984. We'll be right back.
A Noble Lie, Oklahoma City, 1995, will change forever the way you look at the true nature of terrorism.
Based on the damage pattern to the building, what the government says is impossible.
The grand jury did not want to hear anything I had to say.
The decision was made not to pursue any more of those individuals.
Some of these columns were ripped up, shredded, tossed around.
The people that did the things they did knew doggone well what they were doing.
Expose the cover-up now at ANobleLie.com.
HempUSA.org has moved and expanded its operations for faster worldwide shipping. Our product line has grown from 5 to nearly 100 items in less than 5 years. Our food has grown naturally, always chemical-free, not found in stores. Great for daily intake and perfect for your emergency storage shelter. Call 908-691-2608 or visit HempUSA.org and see what our powders, seeds, and oil can do for you.
It is so enlightening to listen to 90.1 FM, but finding things on the internet isn't so easy, and neither is finding like-minded people to share it with.
Oh, well, I guess you haven't heard of Brave New Books then.
Brave New Books?
Yes, Brave New Books has all the books and DVDs you're looking for by authors like Alex Jones, Ron Paul, and G. Edward Griffin. They even stock Interfood, Berkey products, and Calvin soaps.
There's no way a place like that exists.
Go check it out for yourself. It's downtown at 1904 Guadalupe Street, just south of UT.
By UT, there's never anywhere to park down there.
Actually, they now offer a free hour of parking for paying customers at the 500 MLK parking facility, just behind the bookstore.
It does exist, but when are they open?
Monday through Saturday, 11 a.m. to 9 p.m. and 1 to 6 p.m. on Sundays. So give them a call at 512-480-2503 or check out their events page at bravenewbookstore.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Mr. Officer, you're taking the law in your hand. Won't you follow the law of the land? I don't understand. Your job is to protect and to serve, not beat and abuse.
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Ruleville Radio. And Larry, I see you there. I probably got one more segment. I could do another 2 hours on this, but I'll go over this real quickly. We have paragraph 20, then we have paragraph 24. In the deed of trust, the lender is named, the borrower is named, the MERS, if MERS is in the contract, and the trustee. In paragraph 24 on who can appoint a substitute trustee, it very clearly states the lender may appoint a substitute trustee or someone with power of attorney for the lender. Now, this goes to the statement Eddie's always making about what is it not included is excluded. We've probably all heard the term, the exception proves the rule. And when I heard that term, I thought it sounded pretty ignorant, and it's because I didn't understand its context. And what would have made it make more sense if it said the exclusion implies the rule. In this case, there are 4 entities mentioned in a deed of trust that has MERS in it: borrower, lender, MERS, trustee. In paragraph 24, it authorizes the lender to appoint a substitute trustee, not MERS. MERS is mentioned in the contract. Therefore, if the framer of the contract intended that MERS have this power, they would have been included. What's that Latin saying, Eddie?
Inclusio unus est exclusio alterius?
Alteris. It's got an R in it.
The inclusion of one thing is the exclusion of all others?
That's exactly where this goes to. So if you have MERS doing an assignment, then the assignment is bogus, but it's been bogus for an even better reason. And anybody who's fighting these issues, you are going to like this one. As an engineer, every time we design something, never works. At least the first time. Because almost invariably, there will be some factor we overlooked. Some minor little condition that was too simple and we didn't focus on it. So when we do all the sophisticated stuff and put the piece together and it doesn't work, then we try to deconstruct. We try to go back to the basics. And that's not as easy as it sounds like, because where do you go back to? You know, we could go all the way back to the birth canal or to yesterday. So somewhere in between here, we skipped over an important piece. And in this case, we go back to what constitutes a contract. We have this deed of trust, and for 200 years, the deed of trust appointed a trustee, and it granted certain concessions from the borrower to the lender. And for 200 years, the borrower never signed the contract. Didn't need to, because there was nothing in there where the lender never signed the contract, because the lender wasn't conceding anything. He wasn't granting anything. Everything was being granted by the borrower. And then they put MERS in the mix. And MERS is listed as the beneficiary. Well, if it is the deed of trust that makes MERS the beneficiary, then by necessity, the deed of trust would have to transfer the beneficial interest in a mortgage loan is the right to payment on the note. The deed of trust would have to transfer that right from the lender to MERS. And then it goes on to state that MERS holds legal title. Now, if this were in fact a trust document, which I assure you it is no such thing if MERS is involved, because in a paragraph entitled Transfer of Property Rights, the property rights or legal title is transferred to the trustee. But if MERS is included in the contract, the very next paragraph. Now, if you look at your contract, most of them will have a footer on it that says Fannie Mae, Freddie Mac, uniform instrument, 3041 if it's Texas, 3005 if it's California, and each state has its own, but they're almost all identical. And if they have MERS in it, they're still almost identical. But the ones with MERS in it are not identical to the ones without MERS in it. And where the differences come in is in this transfer section. Some of the transfer sections actually transfer the property to the deed of trust. Others transfer it to MERS. Even those that transfer the property to the trustee in the transfer property rights paragraph, the very next paragraph, in the uniform instrument, that paragraph covers any additions to the property, any repair to the property, anything that would add to the value of the property becomes a part of the collateral included in this deed of trust. And that's reasonable. If you add a garage onto the property, if you add a second floor on the property, the lender is not going to want to foreclose on the first floor. He's going to want both, and that's reasonable. But in the one with MERS in it, they add a section in there that calls MERS the beneficiary and states that it is understood that MERS only holds legal title. Now, wait a minute. If they were the beneficiary, they would hold equitable title. And in a normal trust, you transfer equitable title. In a normal deed of trust, the lender, by the nature of the transaction, holds beneficial interest and is the beneficiary. He holds equitable title. And in a trust, the legal title, which is granted to the borrower by the lender in a warranty deed, that legal title is transferred by the borrower to the trustee. And now these are saying that MERS holds legal title. So, in order for these provisions to be binding, the lender would have to sign the contract. But the lender did not sign the contract. See, I missed one part. In a mortgage, the property would be transferred to the lender. The lender would hold both equitable and legal title. In a deed of trust, lender holds equitable title, trustee holds legal title. In this case, they're taking a deed of trust and turning it back into a mortgage because they're moving legal title from the trustee to the beneficiary, who's also the holder of the trust, MERS, who's actually holding them both. And this becomes a grant. In Texas, it is absolutely forbidden by statute for a lender to require the property against which the loan is made to be transferred to the lender. It's forbidden by statute, so we can't have mortgages here. They would be forbidden. But that's what this document comes out to be. That's what it would be if the lender actually signed it. But since the lender didn't sign it, that section appointing MERS is null and void. That's probably the biggest claim that we have, and by far the simplest claim for a local judge to look at and be able to wrap his head around. In Texas, I think it's 5.072, verbal contracts are forbidden in real property matters. All contracts must be in writing. They must be signed by all interested parties. Now, they may be able to do this kind of thing in other states, but they certainly cannot do it in Texas, and I suspect it's going to be the same in other states once I get to that portion of the research. Well, I've got a whole lot more, but that's all I have time for today. So that's my story, and I'm sticking to it. When we come back, we're about to go to break. I want to go to you, Larry. I'm sorry to hold you up this long, but I was just having way too much fun to quit. So probably tomorrow I'll talk some more about some of the other issues with the deed of trust and how we can take these issues to a lower court and use these issues to get things like assignments and appointments of substitute trustee tossed. And that way we undermine the whole foreclosure. This is Randy Kelton, Deborah Stevens, Eddie Craig. The Wheel of Law Radio, our call-in number 512-646-1984. We're going to go to the phones next, so call in if you have a question or a comment, and we'll be right back on the other side.
The Oklahoma City bombing. Top 10 reasons to question the official story. Reason number 2, why was the ATF AWOL? Paramedic Tiffany Bible, who was on the scene within 5 minutes, has stated in an affidavit that agents of the Bureau of Alcohol, Tobacco, and Firearms told her that they were not in their office that morning. EMT Catherine Mallett also overheard one agent say to another, quote, "Is that why we got the page to not come in today?" End quote. Bruce Shaw, as interviewed on KFOR TV, was also told by ATF agents that they had been paged to not come into work. The ATF initially denied these claims and now variously claim that one of their agents was in a free-falling elevator, which has been disproven, or that they'd been in an all-night stakeout, or that they'd been at a golf tournament. As they try to sort out their lies, all we want to know is, did the ATF receive a warning, and if so, why did they not pass it on to others in the nerve level? For more information, go to okcbombingtruth.com.
Are you the plaintiff or defendant in a lawsuit? Win your case without an attorney with Jurisdictionary, the affordable, easy-to-understand 4-CD course that will show you how in 24 hours, step by step. If you have a lawyer, know what your lawyer should be doing. If you don't have a lawyer, know what you should do for yourself. Thousands have won with our step-by-step course, and now you can too. Jurisdictionary was created by a licensed attorney with 22 years of case-winning experience. Even if you're not in a lawsuit, you can learn what everyone should understand about the principles and practices that control our American courts. You'll receive our audio classroom, video seminar, tutorials, forms for civil cases, pro se tactics, and much more. Please visit ruleoflawradio.com and click on the banner or call toll-free 866-LAW-EASY.
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. And we're going to go to the phones. We're going to go to Larry in Texas. I think there you go, Larry. What do you have for us today?
Oh, I have a question about, I recently paid off a mortgage on my home, and since that's the first time I've ever did anything like this, I was wondering if I got enough paperwork from the bank, telling me that I actually own the place now.
Did you get the original note and the original deed of trust back?
No, I have not seen that.
Then you don't know if you own the house or not. So, have you? Okay, I talked to someone about this earlier, and if Gary Lochte's listening, why don't you give us a call? He's been having this same issue. He paid off a property in San Antonio and tried to get the paperwork from the bank, and they couldn't come up with it. Now here's a problem they have. They are required to come up with it. Otherwise, there's reason to believe that they didn't hold it. And in order to be able to get a good claim against them, you really need to be harmed. And thus far, you haven't been harmed. And the court's going to say, well, you're afraid that somebody else will come back and try to collect on the note. Well, you can prove that you paid this off. Well, maybe the court will buy that. Maybe somebody will come along with some really good forged documents and take my house away from me. I had a right to get this back. That was a condition of payment. And I had a guy who was offered me twice the value of the property because he really needed it. And I wanted to sell it to him, but when he found that there had been a deed of trust and a note, and I didn't have the original returned to me, he was afraid that there was a potential claim against the property and he couldn't afford to risk the investment. In that case, you have lost the benefit of the bargain. And in O'Connor's causes of action, that's one of them. You would have a right to claim the benefit of the bargain. Now, I'm not suggesting you do anything improper. But if somebody were to make that offer to you and then not purchase because you had clouded title, you would certainly be harmed. Have you considered suing them?
I hadn't really given it serious thought until just now.
Yeah, well, most people think that filing suit is a lot harder than it is. It's not. It's pretty simple, as a matter of fact, especially with the advent of the Internet. I do a lot of research, and the first place I go for research is just a browser search. I was doing some research today, and I needed the property code that forbid verbal contracts. So I put in Texas property code, verbal contract. Bam, got a hit right on it. That was faster than going to the statutes, even if I knew where it was, that would be faster than going and digging it out. Quick search, bam, I hit it. And if you do a search on this issue, on paid off note, did not receive deed of trust, run that search and you'll probably get a whole stack of people who've done the same thing you're looking to do. You'll get lawyers who've been in the same issue. And they will tell you just about all you need to know. And in order to be a good pro se litigant, there's one skill that you have to develop. And you don't have to be a real whiz-bang paralegal or know all the law relating to the subject. What you have to become is a good plagiarist. Go find the guys who have done all this work and laid it all down in nice, well-written legal documents and plagiarize the crapola out of it. In law, that's absolutely not only acceptable, but it's good practice. Because you don't want to write everything yourself. You don't want your pleading before the court to be any more original than it has to be. Because the judge reads these things all day, every day, and it really gets tiresome after a while. So what the judge really likes, if he's reading a probate issue, he wants to see the same case law on each element of the issue that all the other lawyers use. And where you find that is in the litigation guides. There are probably, for any one issue, there's probably 50 different cases you could use to address the same issue. And each one would probably address the issue just as effectively. But that'll make you nuts. It'll make the judge nuts reading all that stuff. So try to give him the same thing that everybody else gives him, and the easiest way to do that is to plagiarize it. It looks like Larry dropped off, and we have Gary from Texas, and Gary from Texas is an 830 number. I wonder who that could be. Hello, Mr. Gary. Did I get you unmuted? It looks like my caller board is having some drops. Ah, there we go. You're back. Okay, now I got you, Gary.
Hey, am I on?
You are on.
Good.
How is that issue with you going?
Well, actually, there's nothing been resolved. Just to kind of bring everybody up to speed, I paid a promissory note, which was secured by a deed of trust on a piece of property. Paid it off about a year ago, and after about 3 months, I received a copy of a release of lien that had been filed in county records. But I did not receive the original promissory note with our actual wedding signatures on it, and nor did I receive the original deed of trust with original wedding signatures. So I wrote the lender and asked them, I sent in the copy of the release of lien, and I said that I had not received the rest of the paperwork, and I wanted to know when they were planning on mailing it to me. And it took them about 6 or 7 weeks to answer, and they finally actually put in writing that they don't return the original paperwork. And, of course, when I got that letter, Randy, I contacted you and asked you if you had any insight on it. And I've written them, I think, once or twice and requested again to receive the original paperwork. And there actually hasn't been any response to those requests. So one thing I'm thinking, based upon what you have read and talked about this evening, is I think I'm going to start building a case against them, or adding to the case that I've already got. And one of the things that I think I'm going to do, based on what you said earlier, is I'm going to write them and ask them to send me copies of all notices mailed by the original lender and all subsequent lenders. And I'm going to ask them to send me a copy of all notices from the original holder of the deed of trust and all subsequent holders of the deed of trust. And if they have been certified, then that will appear on those copies as copies of the notices. And if it hasn't, then I think that's some pretty good ammunition and documentation that they violated the deed of trust.
Well, also that you don't know if they had authority to collect on the note. Was this the same entity that you got the loan with?
No, it's not.
Then you have no idea. 10 years, 20 years from now, somebody could come back and make a claim against your property.
That's right. To my knowledge, the note was sold. Let me restate this. To my knowledge, I have had 2 servicers on that note. The original and the second, which is I'll just tell you, it's Wells Fargo. And Wells Fargo bought a little bank in Floresville called Bank of the Southwest.
Well, here's the problem they have is if Wells Fargo was in fact the proper servicer, Wells Fargo would also have to be the custodian of the record.
Exactly right. And
as custodian of the record, they are required to have those documents.
Yes, sir. And I have actually written to get the name and the contact information for the custodian of the records. And I'm waiting on that information right now.
You might look in the Texas Code of Criminal Procedure for pre-litigation discovery. It sends your request under pre-litigation discovery. Okay, hang on. This is Randy Kelton, Deborah Stevens, Eddie Craig, Real Law Radio. We're going to our top of the hour break. I see we've got Larry back. Larry, we will get back to you on the other side. This is Gary, and we should have an interesting conversation. Okay, if you want to give us a call, we've got 1 hour left. Our call-in number, 512-646-1984. We'll be right back on the other side.
The Bible remains the most popular book in the world. Yet countless readers are frustrated because they struggle to understand it. Some new translations try to help by simplifying the text, but in the process can compromise the profound meaning of the Scripture. Enter the Recovery Version. First, this new translation is extremely faithful and accurate, but the real story is the more than 9,000 explanatory footnotes. Difficult and profound passages are opened up in a marvelous way, providing an entrance into the riches of the Word beyond which you've ever experienced before. Bibles for America would like to give you a free recovery version simply for the asking. This comprehensive yet compact study Bible is yours just by calling us toll-free at 1-888-551-0102 or by ordering online at freestudybible.com. That's freestudybible.com.
You're listening to the Logos Radio Network at logosradionetwork.com.
Imagine a website that recorded everything its users read while signed in and then published that data for the whole world to see. I'm Dr. Catherine Albrecht, and I'll tell you about a Q&A forum that's a privacy nightmare next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
What's the hottest new website you've probably never heard of? Okay, well, that's a loaded question, so here's the answer. It's Quora, a high-tech question forum that's the rage of Silicon Valley insiders. Named as a potential multi-billion-dollar startup by the New York Times, it's visited by nearly 250,000 people a month. But for all that, Quora has some serious flaws. For one, it requires you to register with your real name. Then it records everything you read, and it lists those topics in your profile. Finally, Quora shares your reading history with the world without any warning. In my book, that's privacy invasion without question. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine. YouTube is making users post their actual names, claiming that transparency leads to better online behavior. But does it? I'm Dr. Catherine Albrecht, and I'll tell you about the push to end anonymity on the Internet in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
YouTube has joined Facebook and Google in forcing people to use their real names. They claim this will make people nicer online, but in fact, there's hard evidence that real name policies don't improve online behavior. In 2007, South Korea mandated a real name web policy, then ditched it 4 years later. Malicious comments decreased by less than 1%, but hackers had a field day scooping up valuable real name data. All this talk about civility is just an excuse to kill anonymity on the web. That's because the big boys want real names to sell to real advertisers and eventually to keep the rest of us in line. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Looking for some truth? You found it. LogosRadioNetwork.com.
Babylon, I'm born down the whole nation, but them operate the land wrong. I'm also Republican and them a scratch man. Tell them I'm a libertarian. Them say we born to lose, but we born to win. Come grab one. Justice and child love rule this time. How what we say? Chant for our wars. Mother, me tell them. Chant down Babylon, chant down Babylon, chant for justice and
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio, and we're talking to Gary in Texas. We also have Larry up. I'm going to bring both of you live. Larry, meet Gary. You're both having the same issue. Okay. And Gary, you were talking when we went out.
Yeah, I was just stating that I'm in the process of building an evidence file, and I am going to initiate an action against them and all of the other lenders that I discover that were in on this thing. And I'm sure I have not gone down to county records yet, but I know if I do, I'm not going to see a complete chain of title. I'm going to see skips in it, and that's probably going to lead to a quiet title action on the property. But yeah, there's one thing I want to say. I emailed you the other day, Randy, and I don't know if you've seen it or not, but I have a real deep concern over the QE Unlimited that the Federal Reserve just announced. And as you know, they're going to be buying at least $80 billion with a B, $80 billion a month in mortgage-backed securities. And I was just thinking about the marriage between the Federal Reserve buying these mortgage-backed securities, which means that all that money is going to go overseas to the global banking concerns. If you marry the QE Unlimited with the fact that they have committed fraud in the county deed records, fraud with our deeds of trust, fraud with our promissory notes.
What? Hold on, Gary. You're getting a lot of background noise.
I'm just talking. I'm sorry. I may be moving in my chair. I'm kind of animated.
Yeah, it picks up other sounds really well.
Okay.
Okay, go ahead. That's better.
I apologize for that. But anyway, I have a real concern that the end game of all this is to confiscate all of the land in the country. I think that they can go in and just say, hey, we own the land. You didn't really pay it off. And as we know, people are getting foreclosed on, even though they've paid their mortgages off in full. And I just can't help but think that with this QE Unlimited going into force, that we're going to see confiscation of property throughout the nation. And I'm really, really, really concerned about it. And I think that everybody who's in a situation similar to what I'm in, we need to go now and initiate actions in our county courts and get quiet title, among other remedies, on our properties right now before, in other words, we need to make the first shot and protect our property so that they can't come and confiscate it in the future. And I don't know if I'm on the ball with that or not, but I'm real concerned about it.
How do you envision them confiscating? Are you saying just through foreclosures or some other method?
Well, right now, all I can tell you is that they're using foreclosure, and they are successful with many of them across the country, even after people have paid off their liens. And the fact that, for example, today, if some lender unknown to me were to initiate a foreclosure action against me, because I do not possess the original note and original deed of trust, what proof do I have that I actually own the property?
Would you be able, with the information you have, to go down to the the Bureau of Lands, or whatever it's called, and get a colloidal title or a land patent?
Well, I've actually filed, about 8 years ago, I actually filed the paperwork for the land patent, and I have it recorded in county records.
Yeah, as I understand, the land patent will not protect you against a prior lien. So what I'm getting at is where you would be harmed if you couldn't file an effective land patent because you still have these potential outstanding claims out there, or if somebody wanted to buy the property and couldn't because of the lack of quiet title.
Could we restate it another way? Could we say that the land patent was not complete because of the possibility of outstanding claimants to the property?
Absolutely.
Yeah. Yeah.
That's the one thing that a land patent won't cure. I've heard people say that even if there's a bank lien against the property, the land patent would overcome it, but I've never seen any case law to that effect.
No, and actually, when people make that statement, it's not true because the promissory note is a contract.
That was exactly what I said. You can't go out and make a promise to pay and then bring forward a land patent and nullify that promise to pay.
Right. That's
that would go against about everything the system was put together to protect us against.
Correct, but what I'm not sure of, I don't think that the promise to pay supersedes the land patent. In other words, the promise to pay doesn't defeat the land patent once. See, it's so I haven't proven it in court, so I can't say one way or the other. But the land patent now should supersede all claims against the property now that the release of lien has been recorded in county records, except for the fact that I don't hold the deed of trust and the original promissory note that pledged the property as collateral.
So someone could bring that promissory note, the original, and say, I hold this note. He doesn't. So I have this claim. Now, you could fight the claim.
Right.
But you would have to. And then you'd have to trust the courts to rule in accordance with the law. And we know how that works.
Right. Well, I want to say in defense of our judges here in Medina County, we've got some pretty good constitutional, law-abiding judges. Now, I'm not saying that they don't have a few skeletons in their closets. I'm not saying that they don't, that they always follow exactly what the statutes command, because they don't. But for the most part, issues like this, I think they would rule in favor of the landholder, at least in this county.
That is good to hear. I hope that is consistent with other counties. I do understand that a lot of the problem goes to the fact that we don't always give the judge what he needs to rule in our favor.
Correct.
So I've been struggling to give the judge something he could use to rule in our favor. And I've been trying to do it from the perspective of not just what the law says, but the position the judge is in, the world he lives in. I'm trying to craft the claims and arguments so that they fit within the world he lives in, so he can give this ruling without seeming to be somewhere way out in left field.
Absolutely. All these ethereal arguments, it's like you say, these people that are sitting in the positions of judge in these courts, they know what they know, and they can't go beyond what they don't know. And you've got to give them something logical and tangible, and something that if they rule against you, they know they'll lose on appeal. And it's got to be clear and concise, and you've got to have the law in your favor. And I wanted to say something else, Randy. That's why programs like you guys have there on Logos Radio Network, y'all's information is absolutely critical and invaluable. And I hope you realize what a real benefit you guys are providing to your listening public, because we don't have the time and effort I work 10 hours a day. I don't have the time and effort to put in studying, but I can listen to you for 3 hours at night or 4 hours at night and get a good education that way. So, we're all in this together, and we all need to pool resources, and we all need to learn. And then we need to go try it out in the courts and maybe get our nose bloodied, but we learn from that. And the nice thing about administrative process is if you get your nose bloodied, you can start over.
I think that's the most important thing for people to understand.
Yeah.
Is go out there and get your nose blooded. Big deal. It'll stop. I mean,
yeah, that's right.
There's not anything these folks can do, but we don't have something we can do in return. People are afraid to step in the arena because they've never stepped in the arena. But I try to convince people, especially when you're the one going after them, like in this instance with you and Larry, you're the ones that be going after them. And when you're the plaintiff, it's a whole different ball of wax. Larry, you back with us?
Yes, sir. I'm back. Yeah,
Good.
I just had one little question when you get through there.
Oh, okay.
Yeah, I'm pretty well done. I just appreciate your program, and as I move forward in this, I'll keep you informed on what I'm doing and what I'm receiving, and maybe we can, pool resources and file a cause of action at some point.
Okay, wonderful. Yeah, I'm glad you were listening so you could come in.
I never miss a program, Randy.
Thank you. That's just good to hear. Okay, take care.
Okay, bye.
Okay, Larry, you had one question for us.
Yes, sir. Yes. As you know, I lost out on part of the phone call, but my question is, whatever you said, does this apply to equity lien contracts on homestead property?
Oh, wait a minute. You kind of broke up on that, so I didn't quite get all of it. But we're coming up on a break, so I'm sorry to hold you off so long, but hang on just a little while to the other side of the break. I got it. Part of that had to do with the equity lien against the homesteaded property. This is Randy Kelton, Deborah Stevens, Eddie Craig, Review of Law Radio. Our call-in number, 512-646-1984. Give us a call. Get in line. We're moving into our last hour. We've only got 45 minutes left, so give us a call. We'll be right back.
At Capital Coin and Bullion, our mission is to be your preferred shopping destination by delivering excellent customer service and outstanding value at an affordable price. Capital Coin features a great selection of high-quality coins and precious metals. In addition to providing the best prices in the nation, we want to bring you the best shopping experience both in-store and online. In addition to coins and bullion, we carry popular longevity products such as Beyond Tangy Tangerine and Pollen Burst. We offer freeze-dried storable foods by Augustin Farms, Berkey Water Products, ammunition at 10% above wholesale, and more. You can lock in a spot price with our silver pool, and we set up metals IRA accounts. Call us at 512-646-6440 for more details. We're located at 7304 Burnett Road, Suite A, about a half mile south of Anderson. We're open Monday through Friday 10 to 6, Saturdays 10 to 2. Visit us at capitalcoinandbullion.com or call 512-646-6440.
Hey, tangy tangerine, see what you've done to me. I'm losing weight and I'm not half the man I used to be. Hey, tangy tangerine, you make me feel so good. I don't eat so much food. Ain't I a sight compared to what I used to be? Calcium, magnesium, selenium, and zinc. Take a moment now and think. If you have a little drink, every day will bring the life that you've been looking for.
Beyond Tangy Tangerine is available at Brave New Books, located at 1904 Guadalupe Street. The bookstore also carries the works of Dr. Joel Wallach, founder of Longevity and creator of Beyond Tangy
Ain't gonna
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. And we're talking to Larry in Texas. And will you repeat that question concerning home equity? I mean, not home equity, a homesteaded property.
Yes, sir. It says that this release of lien that I have, it says it's release of lien on equity lien contract on homestead property. And I believe that was because I took out a home equity and I'm not sure, I don't remember for sure what the loan was. But I think that was a home equity loan.
Yeah, when you get a home equity loan, there used to be forbidden to get those. But with the constitutional amendment, I think it was 51, I don't remember offhand, but they allowed it with really serious restrictions. But I guess I'm not sure what the question really is. Are you asking, can they do that, or what particularly are you asking about that?
Okay, my question is this the same as a mortgage contract, and that I should have a deed of trust that I should be able to get back from the bank?
It is the same in as much as you have a promissory note. The real problem is not the deed of trust. The real problem is the note. Then you can think of the note like a check. And when if you've been around a while, like I have, you'll remember the days that we would write checks before all this plastic, and the merchant would cash the check, and the bank would return the check to us.
Yes.
They would put that document back in our hands so we can be certain nobody else is going to take that document and try to make a claim against it. Your home equity loan is the same way. It is a promise to pay. And if you don't have it back, it's out there. And someone can come along later and say, I realize these guys collected on this, but they never owned it. I actually owned it. And I have it right here to prove that I own it. Now what do you do? Under the Uniform Commercial Code, if you render payment to the wrong person, the note is not extinguished. If you render payment to an authorized agent of the holder, and the authorized agent misappropriates the funds, your note is extinguished. You're not responsible for that. But if you pay someone who just claims he's the authorized agent, and he actually did not have authority to collect it, even if they actually thought that he did, even if he acted in an absolute best of faith, doesn't make any difference. Doesn't extinguish the debt, because the person who legitimately holds the debt has the right to payment. So you could wind up with somebody down the road expressing the same note. They have to give you the note back. Otherwise, your title is permanently clouded.
Okay, you have been a world of help to me.
Okay, and let me tell you, suing these guys is not hard, especially if you're pro se. See, their problem is you don't have to pay $300 to $500 an hour for a lawyer. And I do a Wednesday night conference call, and we had Juan Franco on there last week saying that he believes these lawyers. He sued a lawyer who was trying to collect on the note, and they had to hire another law firm. And he said, these lawyers are just trying to get billing. And in law, they call that churning. These lawyers are churning the case. Now they're doing it to another lawyer. They don't care who they do it to. They screw each other. They don't care. So they'll certainly do it to the banks. So if you go in and construct a good-sounding argument, there are so many things you can do to beat them up with. And, heck, you don't have much to lose. If you sue them in the state court, I think it's like $160, about $200 by the time, $220 by the time you get them served. That's chump change. And for the legal education it'll give you, the one thing you won't believe, and it's hard to express how valuable this is, going in, you're looking at a court system you don't know anything about. And you can expect them to pull every stinking, rotten, low-down, dirty lawyer trick they can find. But if you tune into this show, we will show you how to kick their behinds every way from Sunday. Part of their problem is these guys spend the vast majority of their time dealing with other lawyers. And there are just things lawyers don't do to lawyers. I had a friend that was in a foreclosure issue, and he filed a motion demanding that the lawyer prove up agency. And he got into court, and the judge kind of kicked his behind and told him to come back. They had filed an affidavit that he couldn't verify that it was not a valid affidavit. The judge was all over this lawyer. Told him, you come back to my court with a proper affidavit or you don't come back to my court. So they get out of there, and they're walking out of the courthouse, and the lawyer's saying, I don't understand this. No lawyer would ever do something like that to me. And he said, well, Bubba, I'm not a lawyer. And that's the deal. Lawyers they generally start out around $40,000 a year for malpractice insurance. And here's the deal. And what I'm going to tell you is grossly unfair. And I'm sure it's just going to break your heart when you hear this. If a lawyer gets a bar grievance in his first year of practice, his insurance carrier the reason I can say this is there are 9 underwriters in the country for malpractice insurance. They're all underwritten by Lloyd's of London. They all have essentially the same standards. One bar grievance, your first year of practice, they will cancel immediately. Just like if you buy insurance on your new car and you pull it out and the next day you bash into a tree with it, they're going to pay for that car, but they're going to cancel immediately. 2 bar grievances, any 1 year of practice. If you've been practicing 20 years, they'll cancel. 3, they'll cancel your law firm's malpractice insurance. A lawyer that told me this to start with said a friend of his got out of law school and he didn't get picked up by a law firm, so he went down to the court and got on the attorney wheel. So when somebody needed court-appointed counsel, they would call him on a regular basis, and he used that to pay his student loan and pay his office expenses with till he got known. See, lawyers can't advertise directly. That's a felony. That's barratry.
Right.
They're expected to get their business by word of mouth, but if you're starting out, man, it's tough. And you got this huge student loan. Well, he gets this guy appointed, and the guy disappears. So 11 months later, the lawyer goes to the court and said, I can't find my client, and asked to be removed. Court removed him. Next month, the guy came back, and he was not happy that his lawyer had dumped him. He filed a bar grievance. They canceled immediately. And this lawyer said, that was grossly unfair. And I'm standing there grinning from ear to ear and say, yeah, as a matter of fact, it is. And he looked at me and said, oh, I shouldn't have told you that. You're right. So, and here's their problem. if you file a bar grievance against a lawyer and you accuse that lawyer of running over 10 babies and stealing 20 grandma's estates and throwing them out in the street, they're going to say, well, we examined into your allegation, we find it does not rise to the level of misconduct, and toss it. The problem is your insurance company knows that. Hang on, we'll be right back. This is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. Call-in number 512-646-1984.
This is Building 7, a 47-story skyscraper that fell on the afternoon of September 11th.
The government says that fire brought it down. However, 1,500 architects and engineers concluded it was a controlled demolition.
Over 6,000 of my fellow service members have given their lives.
And thousands of my fellow first responders are dying.
I'm not a conspiracy theorist.
I'm a structural engineer.
I'm a New York City correction officer.
I'm an Air Force pilot.
I'm a father who lost his son.
We're Americans, and we deserve the truth.
Go to rememberbuilding7.org today.
The Rule of Law Radio Network is proud to present a due process of law seminar hosted by our own Eddie Craig. Eddie is a former Nacogdoches Sheriff's deputy, and for the past 21 years he's been studying the due process of law and now offers his knowledge to you at a seminar every Sunday from 2 o'clock to 5 o'clock at Brave New Books, located at 1904 Guadalupe Street. Admission is $20, so please make plans to come by and sit with Eddie and learn for yourself what the true intent of law really is.
At hempusa.org, we offer chemical-free products to people around the world, detoxifying, self-healing, while rebuilding the immune system. We urge our listeners to please consider our largest-selling product, Micro Plant Powder. Our Micro Plant Powder is rich in iodine, probiotics, zinc, and silica to help rebuild the immune system and to create a healthy stomach flora. Micro Plant Powder is excellent for daily intake and is perfect to add to your storage shelter. We urge our listeners to please visit us at hempusa.org. And remember, all of our products are chemical-free and healthy to eat. We constantly strive to give you the best service, highest quality, and rapid shipping anywhere. And we offer free shipping on orders over $95 in the U.S. Please visit us at hempusa.org or call 908-691-2608. That's 908-691-2608. See what our powders, seeds, and oil can do for you at hempusa.org.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Yeah, and who you want to chip? Who you take me for? Free toilet? Who you want to chip? Me no free toilet. You can't chip me. All I'm saying. Don't let them chip you in the morning, chip you in the evening, put a chip in your body. And anyway you go computer reading, you can't hide me say from nobody. When me say, chip in your mom, chip in your daddy, chip in your grandpa and the granny.
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio, and we're talking to Larry in Texas. And this is about strategy. One thing to understand is, you will not win your case because you have the law and the facts on your side. To think so is naive. It is not that way now. It never has been that way since this country started. If you'll think back to the movie Miracle on 54th Street, you have this judge with this trying this old guy. They're trying to put him in the nut house because he claims he's Santa Claus. And do you recall how the movie ended? It ended with the judge's advisor advising him that if you rule against Santa Claus, you will not get reelected. So they brought in all of these letters to Santa Claus, and the lawyer got them to deliver them to the courthouse because they're all in the dead letter file. They didn't have anything to do with them, so he gave them a place to deliver them. So they said, wonderful. They delivered them to the courthouse. And the judge ruled that if the United States Post Office believes he's Santa Claus, so do I. He clearly rendered that ruling not because it had anything to do with law or what was right. He rendered that ruling so he would get reelected. That's how it works in the world you and I live in. Now, that may not be right, but that's how it works. So with that said, it behooves us to figure out how things work, then do it that way. Now, we may not like it, may not agree with it, and it's certainly our prerogative. But first, figure out how it works and do it that way. So, we understand you will not win your case because the law and the facts are on your side. You'll only win your case if you have the politics on your side. So, a lot of what we're about, we need the law to build the political structure on. But it's not so much about the law as it is understanding how it works. For instance, we create political pressure with bar grievances. As I was saying when we went out, if you file really serious, incredibly serious allegations against the lawyer, the state bar is going to toss it. State Bar Association of lawyers, they're not there to beat up on their lawyers. They're there to run interference for them. So we know if you file a valid bar grievance, the bar will toss it. The insurance company knows if you file a valid bar grievance that the bar is going to toss it. So they don't care what the grievance is. They don't even want to see it. By the numbers. If you file a bar grievance against a lawyer, accusing the lawyer of parting his hair on the wrong side, that shyster scoundrel, he should be stripped of his bar card and run out of town. The bar is going to get that grievance, and they're going to say, we examined into your accusation and find it does not rise to the level of misconduct. And so we like it when they do that. I get those back, and I just chuckle and clap my hands. Oh, boy. And when you file a bar grievance, you will never get any really satisfying, positive feedback. Well, not never, but on rare occasions. On rare occasions, the attorney will be so PO'd that he'll gripe to you about it. That gets another bar grievance. What we do is we introduce these guys to the pro se from hell. And you won't believe how much fun that can be. Judges, they get on the bench and they act like gods. H.G. Wells, in his outline of history, on speaking to the corruption of the popes during the Dark Ages. And for the last guy that called me and chewed me out about criticizing the Catholic Church, this is not a criticism of the Catholic Church. This is history. In speaking to the corruption of the popes at that time, he very aptly observed, the giver of the law most owes the law allegiance. He of all beings should behave as though the law compels him. But it is the universal failing of mankind that what we are given to administer, we promptly presume we own. Well, our judges, because they're always the one telling everybody how the cow ate the cabbage, they begin to get the impression that they are the law. I was at a court in Johnson County and wanted to see a hearing they were having, and the lieutenant told me that the judge said it's her courtroom and you're not coming in it. I told the lieutenant, kindly inform the judge that she is mistaken. That is my courtroom, and I very generously allow her to administer it according to my law. And then I asked the lieutenant to go back there and arrest her. He chickened out. But in fact, when you walk into the courthouse, you are the baddest motor scooter in the building. Reason being is you're not caught inside their politics. You can kick them all in the behind. And the thing to understand about politics, The higher someone is up the political ladder, the more politically sensitive he is. Because it's like crabs in a bucket. The higher up you are, the more people you got down below you want your position. I got all the highest judges in Texas put in front of a grand jury once, and I thought it was my eloquent oratory and my really well-constructed, well-plagiarized pleadings. Turned out didn't have anything to do with any of that. Had to do with the fact that Ron Earl was a 25-year district attorney. He was retiring. He was a Democrat. All of these 15 judges were Republicans. Didn't have anything to do with me. And for the most part, you will not get the judges and the lawyers to be afraid of you. What they will be afraid of is the cannon fodder you create for their political enemies. That you can do big time. And I'm in the process of doing some of that now. When you walk into that courtroom, you're the only sovereign in the building. That's why you're the baddest motor scooter there. Everybody answers to you. And when you understand that, it only takes a little while and they'll realize it. That's when you become Mr. It doesn't take me long to become Mr. in a courthouse. If you want to adjudicate the issue, we will show you how to file bar grievances, judicial conduct complaints, criminal charges against a judge. Oh, that is such a hoot. And you never want anybody indicted. And once you understand that, this is not about retribution. It's about fixing something. And it's about politics. And once you understand it as politics, then you become very powerful. You'll come away with this with a sense of control over your life as it compares to the legal system that you never had before. And after that, you get done with these guys, nobody's ever going to want to sue you. Somebody says, I'll sue you. You grin at them and say, take your best shot, brother. I'll break you from that habit. Okay. This is, hang on, Larry. I talked too much that time. We've got another minute and a half. Did that make sense to you?
Oh, it made all the sense in the world. And I'm learning more and more about the true sovereign in the court. And I'm loving everything I'm learning about it because I was like most people. I was intimidated by going to court. And I just didn't know anything about it. But through your program, I'm learning a lot more and feeling more confident.
Yeah, it gets easier. And if there's one thing that I can teach about sovereigns, and we have guys that go around claiming they're sovereign, and you will never, ever hear me claim I'm a sovereign. You'll never see anything like that in a document. I had a guy call in one time, and he said, Mr. Kelton, how do you express your sovereignty? And I knew he was setting me up for a diatribe on sovereignty. And I told him, I act like one. That, once you act like a sovereign, you act like the CEO of this corporation. They call it a corporation. Okay, let it be a corporation. I'm the CEO. And they better not forget it, because I'm going to start griping at the guy at the very top, filing charges against him. And the time I get through with him, everybody down the line is going to be in big trouble. Okay, hang on. This is Randy Kelton, Deborah Stevens, Eddie Craig. Chris, I see you there. We will pick you both up on the other side. Our call-in number, 512-646-1984. We're about to go into our last segment, so I'll kind of cut my blabbing short. We'll be right back.
It is so enlightening to listen to 90.1 FM, but finding things on the internet isn't so easy, and neither is finding like-minded people to share it with.
Oh, well, I guess you haven't heard of Brave New Books then.
Brave New Books?
Yes, Brave New Books has all the books and DVDs you're looking for by authors like Alex Jones, Ron Paul, and G. Edward Griffin. They even stock Interfood, Berkey products, and Calvin soaps.
There's no way a place like that exists.
Go check it out for yourself. It's downtown at 1904 Guadalupe Street, just south of UT.
By UT, there's never anywhere to park down there.
Actually, they now offer a free hour of parking for paying customers at the 500 MLK parking facility, just behind the bookstore.
It does exist, but when are they open?
Monday through Saturday, 11 a.m. to 9 p.m. and 1 to 6 p.m. on Sundays. So give them a call at 512-480-2503 or check out their events page at bravenewbookstore.com.
Are you the plaintiff or defendant in a lawsuit? Win your case without an attorney with Jurisdictionary, the affordable, easy-to-understand 4-CD course that will show you how in 24 hours, step by step. If you have a lawyer, know what your lawyer should be doing. If you don't have a lawyer, know what you should do for yourself. Thousands have won with our step-by-step course, and now you can too. Jurisdictionary was created by a licensed attorney with 22 years of case-winning experience. Even if you're not in a lawsuit, you can learn what everyone should understand about the principles and practices that control our American courts. You'll receive our audio classroom, video seminar, tutorials, forms for civil cases, pro se tactics, and much more. Please visit ruleoflawradio.com and click on the banner or call toll-free 866-LAW-EASY.
Hello? Oh, man, in jail? You got busted, man? Oh, man, I'm broke, dude.
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Real Law Radio. And Larry, I didn't mean to use up all your time, but that is absolutely one of my favorite subjects. And we do. I once did a 3-day seminar on those subjects, so I could talk a long time.
Well, this has been the best phone call I've ever been on.
Well, I'm certainly glad to hear that. But keep listening. We'll be back tomorrow night for 4 hours. And we do enjoy good, hard questions. We're trying to give people remedy. We're not in any way denigrating the system. We certainly don't blame the system for being in the mess it's in. If there is blame to be handed out, it's ours, because we as the sovereigns didn't control it. Remember what Benjamin Franklin is credited with saying to a woman when he walked out of the assembly. She said, "Mr. Franklin, what have you given us?" And he said, "I've given you a republic if you can keep it." It is our job as the sovereigns to keep it. And you really can make a major difference just going in there as the sovereign, not waving your arms and telling them what a big bad sovereign you are, but acting like one. And one of the things I've found really effective is acting like a CEO. I have a little story. Years ago, I was washing trucks for Murphy Motor Freight. And I was at the warehouse, and they were all talking about what had happened that day. It seems that George Murphy was driving down the road, and one of his trucks was pulled over on the shoulder, so he got out, pulled up behind him, got out and walked up to the driver, and he said, "Is there a problem?" And the driver said, "No, I was a couple hours early, so I was just kind of screwing the dog." He said, "Well, I'm George Murphy, and that's my dog you're screwing. Get my truck back to my terminal." Went back and got in his car and went back to the office. He never once spoke to that driver after that. I'm sure you know exactly what he did.
Yep.
He went to the executive vice president and said, "What in the heck is going on? Can't you run my company?" And the executive vice president went to the vice president, the head of transportation, and said, "The boss is on my case, accused me of not being able to run my company because you're not doing your job." And George Murphy, to his credit, gave strict orders that this driver was not to be fired. This problem was not his problem. It was management's problem. So when we think of ourselves as sovereigns, this is how we do it. I just filed a whole stack of criminal complaints with the Chief Justice of the Supreme Court. I'm sovereign. And when I look in Article 2.09 Code of Criminal Procedure that says who are magistrates, very first one, justices of the Supreme Court. And of the justices, he's the top one. So being the CEO, I don't start at the bottom of these chumps down there that can only say no. I start at the guy with the top that has everybody below him trying to take his position. And now he's not going to do his duty as a sovereign, and I'm going to go down to the district attorney and ask the district attorney to present the Chief Justice to the grand jury for prosecution under 39.03 Penal Code for misfeasance in office. And what do you think the prosecuting attorney's going to say?
No way.
Yeah, she's going to see her career flash before her eyes, her bar card turning into confetti. So she's going to refuse. And one thing that we really try to get across here is when public officials don't do what they're supposed to, do not feel betrayed. Do not feel like you've lost or that you've been mistreated. When I ask them to do something they don't do it, I tend to jump up and down and clap my hands because I got this little tar baby. And everybody who touches it sticks to it. And the strange thing about it is each person sticks tighter than the one before. Because I start out with something minor and it gets real serious real fast for everybody. But it doesn't work if they do what they're supposed to. They screw up the whole thing. So the more they do it wrong, the more I get to hammer them. And you never really want to get anybody indicted. We could get rid of all of these public officials and replace them all. We'd be in the same place. I think of my public officials like my grandkids. I love them dearly. But if one of them runs out in the road, I'm fixing to tan his hide. That way he won't run out on the road again. I get a public official not to do his job. If I can get the Chief Justice not to do his duty as a magistrate, and this is going to be absolute bushwhack. He is not going to see it coming unless he listens to this program. I'm going to land on him like a ton of bricks. And everybody that tries to shield him, I land on them like a ton of bricks. And when I get done with this, I'll get magistrates doing their job. That's the whole purpose. I do not want to harm the Chief Justice. I just want them to follow law. They follow law, I got no complaints. Okay, call board is really filling up. Call us back tomorrow, Larry. You really got me going on this subject, and this is one of my favorite subjects.
Okay, I will. Bye-bye. Ray.
Okay. Thank you, Larry. Okay, we're going to go to Chris in Texas.
Hey, Randy.
Chris, I know you have been starting trouble.
Actually, I just called to offer you my help since you help me so often. And my help in the way of, if you ever need a note from a specific lender to read something from it, let me know. I see these notes by the hundreds every month. And it's because I'm a notary, and I work for a major company that does that specific job. We are the notaries that close these loans.
Ooh, I would very much like to sit down with you. What part of what we're doing here is we're taking a real close look at these notaries, and one in particular is the notary who does the closing. And that one's our favorite because the borrower was there and the notary was actually physically there. He did everything the notary was supposed to do. So when we send that notary a request for a copy of his sequential ledger, he's going to send it back to us. And then when we send every other notary that we find in the court records a request for their sequential ledger, we're not going to get one. Because we know they hire someone who's entry level, and then the law firm says, we need a notary, we'll pay for your notary appointment. So they pay for it, and they get them the stamp and everything, and then they sit them down, and they bring them a whole stack of paperwork, and they say, here, sign all of these. I know they do that because I did it. I'll tell a story about it somewhere else. I wound up notarizing my own bond form. That was a hoot. But they get these people to do that, and then when they need a notarized document, they just drag it off the shelf. The reason I'd like to sit down with you is I want to find the best way to get that person who was induced into doing this and probably had no idea of how illegal it was. The best way not to engage them, but get them to feed me the one who put them there. Does that make sense? I think I lost him. Oh, there you are, Chris. Somebody muted you. Okay, there you go, Chris. You're back.
Okay.
Does it make sense where I'm going?
What I've heard so far makes sense, but I actually, my phone dropped the call, and I had to call back in and then pick up where you were at.
Okay. The reason I want to talk to you is we, I've got a program here where I examine the county records. I take them apart piece by piece. And one of the things we really go after are notaries. And I especially like the notary that notarizes the deed of trust. And the reason I like that one is because he was actually there. And he actually did it right. And on the notaries for the deed of trust, you never see the notary's name stamped in with a rubber stamp. You never see all of the writing on the jurat in the same hand except the signature of the notary. I go down to the bank and they notarize a document for me. They fill all that stuff in by hand. They don't use rubber stamp crapola. But when I look at the court records, everything is rubber stamped. And, okay, I ran out of time, but we request the sequential ledger from the notary who did the trustee sale, and we get it. We request the sequential ledger from everybody else, and we don't get it. So that's why I like yours, because we get it. And we can say, why don't these other guys have it? Give us a call back tomorrow night. I would like to talk to you on the air and give everybody a good idea of what to look for. And Alicio, I'm sorry I didn't get to you. Give us a call back tomorrow night. We've got a 4-hour show. We will get to you then. This is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. We'll see you tomorrow night. I'm like a stepping razor. Don't you watch my size? I'm dangerous.
Bibles for America is offering absolutely free a unique study Bible called the New Testament Recovery Version. The New Testament Recovery Version has over 9,000 footnotes that explain what the Bible says, verse by verse, helping you to know God and to know the meaning of life. Order your free copy today from Bibles for America. Call us toll-free at 888-551-0102 or visit us online at bfa.org. This translation is highly accurate, and it comes with over 13,000 cross-references, plus charts and maps and an outline for every book of the Bible. This is truly a Bible you can understand. To get your free copy of the New Testament Recovery Version, call us toll-free at 888-551-0102. That's 888-551-0102. Or visit us online at bfa.org.
You're listening to the Logos Radio Network at logosradionetwork.com.